What happens when a young man with no prior criminal history finds himself standing before a judge, facing not one but two separate criminal cases tied together by the same underlying problem? Today's courtroom hearing takes us through a story involving alcohol, poor decisions, a relationship that spiraled out of control, and a judge trying to determine whether punishment or rehabilitation is the better path forward. On one side, we have a defendant accused of driving while heavily intoxicated after a late-night trip to McDonald's went terribly wrong. On the other, a separate assault case connected to a messy breakup and an emotional living situation that seemed destined for conflict. As the hearing unfolds, the judge digs into the details, questions the circumstances, and examines whether this defendant has truly learned from his mistakes. But here's the interesting part. Despite the seriousness of the allegations, nearly everyone involved, the defense attorney, probation officer, and prosecutor, seems to believe this young man deserves another chance. The question is whether the court agrees. Watch closely because the judge's comments reveal exactly what factors matter most during sentencing, and some of the decisions made today could significantly impact the defendant's future.
All right, I stopped the record and the live stream to separate these matters. We were mostly able to resolve our civil cases this morning. All right, I have to get back into non-translator mode here, where we can speak in full sentences. Let's return to what we started. People versus Mark Bradley Wittenberg, file 251382 SD, as I indicated, originally alleged operating with a high blood alcohol level or while intoxicated. That matter was reduced to a charge to impaired driving. Defendant entered plea. Oops. Oh. Phew. All right, let's try again. These are in the matters of Mark Bradley Wittenberg, file 251382 SD. That case is alleged that on July 13th of 2025, the defendant was operating a vehicle with a high blood alcohol level. That matter was reduced to a charge of impaired driving, and the matter was set for sentencing this morning. Defendant is represented by attorney Luke Knopfinger. Defendant has another case which is alleged to have occurred on December 15th of 2025. That alleges assault and battery and domestic violence. In that case, the defendant pled to a charge of domestic or assault and battery on an ancillary person, and that was Grant. Gage Knight. Both matters were set for sentencing today. Mr. Knopfinger indicated he was going to ask for Holmes Youthful Trainee status in the assault case. Daniel Frazine drew the ticket for the screening and sentencing and has prepared a very good screening report in this matter. I was looking at this. I'm always distressed when it takes a long time. This took all the way from last July to June. It took 11 months to get here, and I'm not really sure why. It was originally assigned to Judge Pattison, and it got adjourned a couple of times. It was set for jury trial in January. I'm not sure what happened. At any rate, it was set for jury trial on my docket in April, and the matter was resolved and set for sentence here today. He actually entered a plea on May 11th.
Right away, the judge highlights something that often frustrates courts across the country: delay. This case took nearly 11 months to reach sentencing, and the judge makes it clear that he isn't entirely sure why. While delays can happen for many reasons, including gathering evidence, negotiating plea agreements, or investigating possible defenses, long gaps between an offense and sentencing can complicate a case. Witness memories fade, circumstances change, and courts must evaluate who the defendant is today versus who they were when the crime occurred. What's notable here is that the defense explains part of the delay involved investigating a potential medical condition that could have affected the field sobriety tests. That matters because it suggests the defense wasn't simply stalling. They were exploring whether there was a legitimate explanation for some of the evidence. What do you think? Should courts move cases as quickly as possible, or is it worth taking extra time when additional investigation could affect the outcome?
I'm not sure what took so long, but anyway, we're here. So let's start with the drinking driving case first. And this is helpful. Both of these are state statute cases, and Abby Stoll is here for the prosecutor's office, and she's got the big picture. Luke, what would you like me to know about?
Yeah, thank you, Judge. And I can fill the court into part of the delay was investigating whether or not a medical condition could have affected the field sobriety tests. So there was a collection of medical records, so on and so forth. So that contributed to that delay. What I'd like the court to consider is a couple things that prior to this, Mr. Wittenberg had no criminal history. He's very forthcoming that alcohol was an issue. These two cases are similar in some ways. And with the, and can I address both cases at once too?
Sure, that's fine.
Because the other one deals with a real messy breakup with his former significant other. He has since moved out. They don't have any contact. So I think it's important for the court to know that. He is a very, very responsive. He's done some of the things that have already been asked of him to do. I don't think he's going to have any problem on probation. We are asking for the Holmes Youthful Training Act on the assault and battery. He is gainfully employed. In fact, he was working just hours ago, Your Honor. So it is good for him, especially the impaired driving, so that he can still go to and from his job without interruption. I do think he can complete the probation without issue with the recommendations as they are.
The defense strategy here is becoming very clear. Instead of denying wrongdoing, the attorney is emphasizing accountability, cooperation, employment stability, and personal growth. In sentencing hearings, that can be far more effective than trying to minimize obvious mistakes. Notice how the attorney repeatedly points out that the defendant has no prior criminal history, has maintained employment, has complied with requests already made by the court system, and has removed himself from the unhealthy relationship environment connected to the assault case. These are exactly the kinds of factors judges often consider when deciding whether someone deserves probation rather than harsher sanctions. The request for Holmes' youthful trainee status is especially important because it offers eligible young offenders a chance to avoid a permanent criminal record if they successfully complete probation. The court isn't just deciding what punishment fits the crime, it's deciding whether this defendant is someone who can realistically be rehabilitated.
We would ask the court to adopt them with the allowance of the Holmes Youthful Training Act on the assault and battery case.
All right. Let's talk about the drinking driving case first. This is another one of those quintessential, you go to McDonald's cases in the night when you should have just stayed home. Although McDonald's wasn't very far from where you were living on Main Street. But a guy in the line contends that you hit him. And I believe him more than I believe you. He got mad enough to come out and yell at you, mad enough to call the police. You're in the line. Your version is you forgot your wallet and you were going to go back home to get your wallet. So you never even got any McDonald's. At that point, last July, you were still with your girlfriend. You had quite a bit to drink. Your blood alcohol, the PVT was a 194, and then it was higher at the actual test.
This portion of the hearing gives us a fascinating glimpse into how judges evaluate credibility. The judge openly states that he believes the other driver's version of events more than the defendant's account. That's a significant observation because sentencing judges frequently assess not only what happened, but whether they believe a defendant is being completely honest about it. At the same time, the judge acknowledges something many people overlook. Intoxicated individuals can still be cooperative. Being respectful toward law enforcement doesn't erase criminal conduct, but it can influence how a court views a person's character and willingness to accept responsibility. The judge also highlights the defendant's extremely high blood alcohol concentration, which becomes a recurring theme throughout the hearing. Even though the charge was reduced, the court clearly hasn't forgotten how intoxicated the defendant allegedly was. This raises an important question. Should a defendant receive credit for cooperation when the underlying conduct was particularly dangerous?
It's interesting to note the police indicated that you were very cooperative, although drunk, in that circumstance. Mr. Frazine, you had an interesting discussion with the defendant. What's your position here?
Well, I had talked to him about the victim impact panel, and within 2 days he called me and said, I actually told him the site. I looked up all around the phone. I said, here's the site. It's like $3 more than ours. And if you want to, because if you get on probation, we want it in person. But if you can get ahead of yourself, call me back 2 days later. Boom, he did it. I thought he was very upfront. He didn't try to sugarcoat anything, which is kind of very refreshing in these kind of cases. He just said that he had basically been young and self-medicating with some depression. He had dealt with his PCP and gotten prescribed something a while back. He probably should have stayed.
PCP, you're talking about his primary care provider.
Yeah, sorry. Yeah, clarify that. The interesting thing I thought of, and I would be inclined to believe somebody else too in the drive-line, but I've actually seen situations where both people are drunk in a Taco Bell or a McDonald's. The police didn't really follow very well with the other guy. There was no report, and he hit my car. I'd want an accident report and stuff. So, 50-50. Obviously, he shouldn't have been driving a .228 and a 208. He was very intoxicated. The accident may or may not have happened. That would kind of tip the scales as far as a presumption of fines and costs in here. But because of they're kind of paired with the domestic case, well, it ended up being pled to assault and battery. I didn't think there would be any benefit to having him on 2 probations. So my thought was just to close out the drunk driving. He already showed that he's going to listen, take charge, and follow my instructions. Like I said, he went and did the VIP within 2 days of me suggesting it. So I was recommending that we address any possible substance issues. I really think it's more of just an unhealthy coping matter. And it's also why I kind of went back and forth between anger management and PD because of his family history.
Listen carefully to what the probation officer is saying, because it may be the most influential testimony in the entire hearing. Rather than portraying the defendant as a chronic criminal, he describes someone who appears to have been using alcohol as an unhealthy coping mechanism while dealing with depression and personal struggles. Even more importantly, he points out that the defendant immediately completed recommended programs without resistance. Judges often pay close attention when probation officers describe a defendant as proactive rather than reactive. The distinction matters. Someone who takes steps toward improvement before being ordered to do so can appear more committed to change than someone who only complies after facing consequences. The probation officer is essentially telling the court, this person has already started moving in the right direction. That's a powerful message during sentencing and could significantly influence the judge's final decision.
Being young, the DD's a little bit more intensive, but it is his first offense and he is young, so I put down anger management. I leave it up to the court to decide.
I think the plea was actually to the assault and battery complainant who was not a domestic partner.
Right, we can do the height of it.
Yes.
And that actually, I was going to put that in. I must have forgotten to put that in. It was in my notes to recommend the height for this.
All right.
So that's what I wrote.
Abby, I tend to agree with Daniel. Had this case just been a drinking driving case, I would have put him on probation. There's a presumption that there isn't probation, but there's this fender bumper incident and he was very intoxicated and he needs some services. But I agree with Daniel, there's no sense to have two probations. And we're gonna do the probation in the assault and battery. Domestic violence has a specific statutory provision that allows the cases to be deferred. Assault and battery does not, which is why your counsel is asking for a special probation status in that case. Abby, I gave you the last word today. I guess I'll give the defendant the last word, but do you have anything that you wish me to know?
Your Honor, I believe that the recommendation in the OWI case is appropriate. Unfortunately, we didn't get any victim input from either victims in the assault case. I understand though that the defendant is young, and I believe and appreciate that he's trying to learn from his mistakes and turn his life around, so to speak. So I believe that the height of probation is appropriate, which is why I recommended it.
Your Honor, I did try to reach out to both victims. I wasn't able to hear from them, but I did speak to Miss, I was saying Chesky Nicole, and she did say that the Gage did contact her via phone, I believe it was.
At this stage, nearly every major participant in the courtroom seems to be aligned. The prosecutor supports the recommendation. The probation officer supports the recommendation. The defense obviously supports the recommendation. That's not something you see every day in criminal court. Usually, there's at least some disagreement about the appropriate sentence. Here, however, the discussion has shifted away from determining guilt and toward determining the most effective path forward. Another interesting detail emerges regarding the alleged victims. The court was unable to obtain formal victim input, and one individual reportedly expressed a desire to move on rather than continue pursuing the matter. While victim preferences don't determine sentencing outcomes, they can sometimes influence how a court evaluates the broader circumstances surrounding a case. The judge now faces a critical decision: balance accountability with rehabilitation while ensuring public safety remains protected.
And stated that he didn't even want charges pressed against him, he just wanted to move on. But I had nothing in writing or other than that.
All right. Mr. Wittenberg, I guess you get the last word. What would you like to tell me? You don't have to say anything if you don't want to, but both your lawyer and your probation officer were impressed with your owning this. So is there anything else you want to tell me?
I would just say I'm very motivated to move forward and put that past and be better from my mistakes that I made.
Where are you working?
Display pack in Cedar Springs.
Yeah, I saw that in the report. What do they do?
We make plastic containers for Meyer and different companies.
Where is Cedar Springs?
It's north of Grand Rapids, it's right at the top of Kent County.
All right, just inside of Newaygo County?
It's a little below Newaygo.
So you've moved to Cedar Springs?
I moved to Grant, Michigan. About a mile north of Kent County, the line.
All right, well, that means that you're not in a circumstance where you're gonna have contact with the complainant. Let's do the impaired first. Now, this is an expensive proposition. This happened a year ago. I'm gonna do, normally I might have done something different, but I'm attaching this to the other case. So 1 day jail credit, 1 day. There's no probation in this case. There is a $300 fine and $125 of minimum costs, which is $425. We'll make it due as part of probation. Concurrent with the assault and battery charge, 2588. One of these was in July and the other was in December. And so you were still struggling with the same issues you were struggling with in July as you were in December. You were in a circumstance which was weird. You and your girlfriend were broken up, but still living in the same house. She apparently had the new relationship with this other guy while you two were still living together.
The judge's explanation here is remarkably direct. He describes the relationship situation as a recipe for problems, and frankly, it's easy to understand why. According to the facts discussed in court, the defendant and his former girlfriend had already broken up but were still living together when another individual entered the picture. Situations like that can create intense emotional tension, jealousy, resentment, and conflict. Now, none of those emotions excuse criminal behavior. Courts consistently reject the idea that difficult circumstances justify assaultive conduct. However, judges often consider context when deciding whether someone presents an ongoing risk to the community. In this case, the defendant has moved away, changed his living environment, and no longer appears to have contact with the individuals involved. From the court's perspective, that separation may reduce the likelihood of future incidents. The question becomes whether removing the source of conflict also removes the risk of reoffending.
Shows up at the door, and that's a recipe for problems, which is what happened. In the assault and battery case, I do have some bond money. He got arrested on
I believe there should be a 2-day credit, Your Honor, not a 1 day.
on the impaired,
On the TV.
on a 2-day credit. All right, on the assault and battery.
I have 1 day for the OWI.
12 days jail, credit 2, leaving 10 days to serve. Of the 10 days, 12 days, 10 are deferred. So you're not going to do any additional jail if you do what I ask you to do. Fine, and this was a 0. I put a fine in the other one. This carries a $75 crime victims' rights fee, $50 state minimum fee. I put the attorney fee in this case, which is $150. I'll do a 12-month probation, which is $480 probation oversight fee. We will allow Holmes Youthful Trainee status. I need to pay for the class. So I'm going to send you to anger management.
This is where the court's priorities become crystal clear. Rather than focusing exclusively on punishment, the judge is imposing conditions designed to address the underlying issues that appear to connect both cases. Anger management, substance restrictions, alcohol testing, probation supervision. These conditions aren't random. They directly target the behaviors and decision-making patterns discussed throughout the hearing. Notice also how the judge frames probation as an opportunity rather than simply a penalty. He's essentially telling the defendant that successful compliance could shorten the process and save money, while failure could result in more serious consequences. That's a common judicial approach when dealing with younger defendants who appear capable of rehabilitation. The court is creating a structured path forward while making it clear that responsibility ultimately falls on the defendant. Whether this becomes a success story now depends largely on the choices he makes after leaving the courtroom.
No drugs and no alcohol, and test as directed, which would be what we would do in the drinking driving case. It was called a timeout. You were burning the candle at both ends and the middle. So you're going to have, and I think you've already done this. It's been a year, but while you're on this probation, you can't drink any alcohol, use any controlled substances, including marijuana. And if you hold up your end of the deal, you can get this discharge sooner than 12 months. If you can do it in less than 12 months, which will have to do with the class primarily, you can save $40 a month for each month you get done sooner. Do you have family up near where you live?
I'm living with my aunt, Your Honor.
That's what he said in the report. So how'd you end up going up there?
I just talked to her about it, said it would be better for me to get out of sort of the environment that I've been in.
Sometimes that's a great plan. Sometimes you take your problems with you. You're working third shift. That's not much fun. It's hard to get in trouble when you're working third shift. You're either working or sleeping.
One of the most revealing moments in the hearing comes when the judge discusses the defendant's decision to move in with his aunt and start over in a different environment. Courts frequently hear defendants promise change, but judges often want to see concrete actions rather than words. Relocating, maintaining steady employment, separating from negative influences, and establishing a support network are tangible steps that can signal genuine progress. The judge even acknowledges an important reality. Sometimes changing locations helps, and sometimes people simply bring the same problems with them. That's why probation conditions remain in place. The court isn't blindly assuming success. It is creating accountability while giving the defendant an opportunity to prove he can make better decisions. At this point, the hearing feels less like a debate over punishment and more like a test of whether the defendant can successfully rebuild his life.
But I think you can do this probation even though you're residing in that other county. I want you to go with Daniel. Now, he may be able to do this course online. And
Well, I think we already talked about that. There's some options up there.
all right, we'll work on that. All right, Mr. Wittenberg, do you have any questions?
No, Your Honor.
All right, this is a combination of assault and battery and OUIL, and I think we got all the conditions we need in the case you're on probation on. The impaired will stay on your record. That's not part of the home's probation. Will restrict your license, which is better than suspending it. That was actually a pretty generous plea offer considering how high your blood alcohol level was. So a year's passed. I think we're in a better place than we were last July, even last December. You go with Daniel and he'll get you plugged into what you need to do to complete this probation.
Thank you.
As this sentencing hearing comes to a close, the court reaches a balanced resolution. The defendant receives penalties for the impaired driving conviction, including fines, costs, and license restrictions, while avoiding additional probation on that charge. For the assault and battery case, the judge grants Holmes youthful trainee status, places the defendant on probation, orders anger management, prohibits alcohol and drug use, and establishes conditions designed to encourage long-term rehabilitation. Throughout the hearing, one theme remained constant: accountability paired with opportunity. The judge repeatedly acknowledged the seriousness of the defendant's conduct, particularly his extremely high level of intoxication, while also recognizing his cooperation, employment history, willingness to complete programs, and efforts to change his environment. Ultimately, the court determined that structured supervision offered a better path forward than harsher punishment alone. The defendant now has a chance to move beyond these mistakes, but only if he follows through on every condition imposed by the court. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Thank you, Andy. What? No, it's fine where it is.
What? I watched the room again.
Oh, yeah.
Luke, still no word from Ms. Wyrick?
No, Judge.
Do you have any reason to think she might actually show up on Wednesday?
No idea. No idea.
Well,
It was never sort of a discussion about, oh, here's a little angle at trial that we may have. So,
we've called off the jurors. I didn't know if I was gonna make you drive all the way over here, or maybe you could just zoom in Wednesday morning at 8:30 and see whether she comes.
okay.
If she doesn't come, Abby will be here with me. If she doesn't come, I'll issue a bench warrant. Of course, she's got a court date a few days later on the new stuff. So Tiffany, I know you watch this channel. Call your lawyer. Luke's waiting to talk to you. All right, thank you both.
Thank you, Judge. Judge,